All right, so welcome to 2021. I'm Regina Gibbons, Executive Director of Why Not, and we are here to kick off the first of many Parent Power series. Today we will talk about estate planning and are you prepared? If you are watching Facebook Live, I ask that you like and share the page and continue to follow us for more of these events. Now down to business. I'm delighted to introduce you to Attorney Stevenson, who has a wealth of knowledge to share with each and every one of you. So get your notebooks, your pens, your pencils, and open your brains and get ready to absorb the information. Without further ado, Attorney Stevenson.
Thank you, Regina. My name is Samra Stevenson, and as Regina has so nicely introduced me, I'm an attorney. I practice primarily in Maryland, also in other states, but we are in Maryland, so we'll focus on Maryland today. I have been practicing, I've been out here for about 10 years, and I've been on my own and as a solo practitioner for 5. I just want to introduce myself with my face on the screen before I pull up the slideshow, and I'll do a little bit of intro into my business, and we'll jump into the goals for today, which are mainly to just get informed and have fun. It's just going to be light and easy. Try and have a conversation about about the estate planning process that I like to call the life planning process now, and I'll explain why in a little bit, what parts of it apply to you and why, and then see if you guys have any additional questions. So let's jump right in. Let me share my screen. And I have turned the subtitles on. This is my first time doing that, so if they become distracting at all, please just let me know. I think they might be helpful. Welcome to what happens if something happens to you. We're going to be talking about planning, like I said, life planning, planning for the unexpected, conversations that you ideally would be having with loved ones, people close to you, family, friends, and families come in all shapes and sizes, so I won't make any presumptions about who the loved ones close to you are. So just a little bit about me, a brief introduction. I have a little bit of a animation that I'm going to play for you in a second. Unfortunately, I said it so fast that I have to talk really fast, so let's see if I can keep up this time. All right, so what is an office without walls, and what is the Office Without Walls Collective? Well, my name is Samra A. Stevenson, and I am the owner and operator of S.A. Stevenson Law Offices, which falls under the Office Without Walls trademark and brand, as does Wills on Wheels and SAS Fit Practice and Office Without Walls Virtual Office Solutions. So that's a whole big mouthful to give you an idea of what I do. The big picture is that my brand is Office Without Walls. The purpose is twofold, my mission is twofold, using legal technology to make the law more accessible to people and also improve quality of life for legal practitioners so that we can be better attorneys and better service our clients. The judge that I clerked for taught me that we are servants of the court, and so we should make ourselves available. And so that's kind of what my mission is. Please excuse, I haven't figured out how to not play this twice. 1 second, guys. There we go. All right, so for purposes of today, we're talking about S.A. Stevenson Law Offices, Office Without Walls, Wills on Wheels. Wills on Wheels is the first mobile and virtual estate planning business model in Maryland. Again, the idea was access to justice. I've worked in pretty much every area of the law you can think of, from the private sector to nonprofits, to the judiciary, as a state's attorney, big firms, Arnold and Porter, WilmerHale, mid-sized firms, and finally for myself. And really when landing on that was long story short, is very much about trying to reprogram or be a part of the conversation, reframing the conversation about legal practice and how legal services are offered, just like I've been saying over and over. So I think it's an outdated notion that clients have to come to your office and look at your ego behind you on your wall. When I created Wills on Wheels, the idea was get up, get out, go to clients. And a big part of that, and a big part of what Office Without Walls is, because of taking the walls off of things and making things more visible, is getting out and talking to people about what their options are. And that's what I'm doing tonight. I'm here to talk to you about estate planning options. I'm here to talk to you about what your options are And I'm here to try and be part of the dialogue about why I think should be called life planning. Estate planning is just it doesn't quite capture it. It kind of makes people feel like it doesn't apply to them. Definitely before I became an attorney, definitely would have never thought it would be applicable to me. I think estate planning, I think Fresh Prince of Bel-Air, some estate somewhere. Life planning captures what it is because it deals with real life stuff. My clients are real life people that run into this stuff. And I get people both on the front end and on the back end. So I get the privilege of sharing stories with you that will help you kind of see where you might need to tie some things up for yourself and make sure that you're taken care of and that your family's taken care of. So why did you come today? You came today probably for a lot of different reasons. And I could pause and ask if anybody wants to unmute and let me know why they came, please feel free. I'll pause for a second. If not, it's okay. So maybe you came because you wanted to get answers for your family or for some kind of comfort or assurance about what you, we just survived 2020, right? About, what you need to do to make sure your affairs are in order. Maybe you've witnessed people go through some hard times. Maybe you've witnessed or experienced loss in your family or someone close to you. And it's been a wake-up call maybe. And so maybe you're here to get some answers about that. Perhaps you want to know about how to protect assets. You want some peace of mind with regards to your property, whether that be real estate, property, cash, or some of the intangibles like the life insurance and those types and different types of policies. Perhaps you want to know how to save money and avoid taxes, which while we're still under a Trump administration, is not too much of an issue. Or perhaps it's about your choices and honoring your wishes and the self-care component of it, which I think is really important. The estate planning process, the life planning, making these life choices is self-care. You're taking the steps you need to make sure that you don't end up in a situation where money's being expended or actually you can't be cared for because there are legal obstacles in your way. Because the estate planning isn't just about what happens when you pass away, it's about what happens in the event of incapacity. The documents that you draft as part of your estate planning apply to what happens to your children. It's more than just what happens to you when you pass away and what happens to your things. So whether you're here for self-care, the peace of mind, the comfort, looking at the assets, it doesn't matter. You're going to learn a lot today. I'm going to tell you about what the state's plan for you is, what the state's plan is for you if you don't make a plan. The documents that are part of that making up an estate plan, and the next steps that you might want to take, might want to consider taking, might want to talk to loved ones about taking with regards to making a plan for yourself. So some very basics from the start, do you have a plan in place? Either you have a will or you don't. You have a trust. Even if you have a trust, you have a will. One second. And if you don't, if you were to pass away, it's called dying intestate. And dying intestate just basically means that you didn't stand as a testator or a testatrix in creating your last will and testament. All those fancy legalese words. And so you died intestate. And in the event that you die intestate, the state is going to go ahead and put a plan in place for you. That just basically means that the intestacy laws in the state where you passed away are going to be what apply. And what does that mean? That means that with regards to where your assets go, the intestacy laws spell that out. So if you pass away with a spouse but no kids, it goes to your spouse. If you pass away with no spouse and kids, it goes to your kids. If you pass away, no spouse, no kids, surviving parents or siblings, and if there's absolutely nobody on either side of your family, then the state. And so, the intestacy laws vary in whichever state you're in, but the important part of that is that what happens when the intestacy laws apply and when there is no will in place is that there's a whole bunch of processes that that could be avoided that become long and drawn out for the people who have to take care of them, who you've left behind, and also become expensive. If we're talking about leaving things to our heirs, no matter how much money that is, I'd imagine that your goal is not to have that eaten up in attorney's fees and court costs and having to have trustees appointed to take care of things for minor children and the like. And so that can really drain some of what you might be trying to, if your goal is to try and leave something behind for somebody, no matter how small, that can really eat into it. And keep in mind, it doesn't take much to really change someone's life in terms of a cash infusion. If you look at studies show that so as little as $10,000 can take somebody who's going from paycheck to paycheck to having them have a steady income in terms of a cash infusion if it's invested and used correctly. So it doesn't take much of in terms of what you're leaving behind to somebody to have it make a substantial material difference for them. Another one of the things about, let me back up actually. I'm having trouble with the slides. Forgive me guys, I'm gonna jump out of this. All right, so I also just want to back up a little bit and talk a little bit more about probate. So I like to explain what the probate process is because a lot of times I get people coming into my office and I want to avoid probate, help me create a trust, I want to avoid probate. I find it very helpful to start off by letting people know that nobody can avoid probate. The only way to avoid probate is essentially not to pass away. Why is that? That's because the probate process is the process by which the courts retitle, distribute, and tax assets. So what does that mean to you? A very simple way of explaining that is, let's just say you own the house you're sitting in right now listening to me. Or the car out front is the car you own, your name is on that title. You want to sell that house or that car. To transfer ownership requires signing your name on a dotted line on an instrument such as a quitclaim deed or some other type of transfer document, transferring your title from yourself to that other person. Now you can physically do that if you're here. If you've passed away, you can't do that. So transferring, forgive me, I'm trying to be very careful in using my words because my mother accused me when I was trying to explain this to her of not making any sense. So I'm trying to be very careful. Transferring title, meaning taking your name off a title like to the house or to the car and putting somebody else's name on that title. You can't, signing your name physically to do that, if you're not here, you can't do that. So the court at that point steps in and effectuates or allows that to happen. And so that is part of what the probate process is, a very simplified explanation, but hopefully you get an idea of why it becomes necessary in the event that things haven't been planned ahead. And again, I just want to reiterate, nobody avoids that probate process, even if you think you don't have anything whatsoever. In Maryland, you're still gonna, even if you have nothing, meaning less than 20,000, you're gonna still open an estate and it's gonna be a small estate, but there's still something there, okay? So moving on, so nobody avoids probate. People come into my office, I like to explain that. What people can do is reduce the length of probate and what I say effectively, sidestep probate. Take it from a 12 to an 18-month process to a 3 to 4 month process, 3, 4, 6 month process by taking their assets and again, retitling them into the name of a trust. So taking title and putting the name of a trust or creating a trust and putting the assets into that trust by retitling them. And when you retitle your assets into the name of the trust, it no longer becomes necessary for them to go through probate when you pass, and they can pass down to your heirs in a much more seamless way. So that's when people say they want to avoid probate, I always like to clarify that. So levels of protection when it comes to probate. Number one, if you have no protections, you've died intestate. And that means the intestacy laws that are going to apply where you passed away. If you create a will, you've created a level of protection that allows for you to control where your assets are going, and a number of other protections. And I don't want to get stuck too much on this slide. Another reason why people like to avoid the probate process, or another reason why people, some of the motivations for planning ahead are for the purposes of privacy. So this is the last will of Jackie Kennedy Onassis. It's a matter of public record. This is what happens when you have a will filed with the Registry of Wills, which is what happens when you open an estate. Really, the will gets filed. If you create a will in our office, it gets filed when you create it for safekeeping. It's not a matter of public record at that time. But at the time that you pass, it does become public record. And so why is that important? Because some people don't want all their business out there. So some of the benefits to planning ahead, creating trust, that type of thing when it comes to estate planning is protecting your privacy and not allowing it to be a matter of public record at the time that you pass. All right, I just want to hop out of the slides and just kind of have a conversation. So does anybody have any questions right now before I go any further? Because I can kind of get lost in this stuff and I don't want to, if your brains are going mush, I don't want to keep going without answering questions. Did anybody come tonight with questions about what a will is specifically, or any questions about probate specifically?
I have a question.
Sure.
This is Yolanda. My purpose is understanding probate, which you kind of explained it to me. But then I also have a question of protecting assets while you're alive.
Okay.
If I set up, say, a quitclaim deed that you talked about, or a trust, and I go into a nursing home, are my assets protected if I go there and I don't have a way to pay it on a normal basis? Do they take all of my assets at that point? Because I've seen people who have had their assets taken, and I don't know if it's because they didn't plan a quitclaim or a trust. Do you know how that works?
Yeah, so the government looks back 5 years. So when it comes to somebody going into a nursing home and they're asking for assistance and they don't want to have their assets considered as part of, they don't want those things taken. Planning ahead, that's part of planning ahead. Creating a trust, or irrevocable trust in that instance, and giving somebody else, or a family member or third party, control over those assets for the benefit of that, I'm guessing, older parent or loved one.
Right. Mm-hmm.
Would be the step you would need to take well in advance of that date actually arriving.
Okay. So if they
years.
end up going within the 5-year time frame, then all that planning is null and void at that point.
It can be. It's threatened. Yes.
Okay. Thank you.
No problem. So just to hop back in, so estate planning is the process of making sure your family, team, and clients aren't left with a mess if something happens to you. So what are the different parts of the estate planning? I talked a little bit about probate. I talked about wills, and there's different types of trusts. And I'm happy to answer questions more about that afterwards. But the important part about trust for purposes of today is that if you're leaving assets to a minor child, your minor child cannot take control of those assets. Legally, they cannot take control of those assets until they are 18. Ideally, what I usually advise is that if you want to see your loved one, your heir, your minor child get the most out of that, whatever you're leaving them, is to put some parameters and boundaries around it to make sure it stretches out as long as possible and stays protected as long as possible. So what does that mean? That means making sure that either you've created a trust prior to you passing, or you've created language in a will that directs a trust to be created for the purposes of your minor child, and spelling out some terms such as the minor child won't take possession of said assets or portions of assets or percentages of assets until they reach certain ages. You can be as creative as you want with that. I always use the example of a client who had the directive that the minor child would not inherit unless they were living a godly life. And that's fine as long as you spell out what godly life means and that you're putting somebody in place who's going to have the discretion or, monitor whether or not those standards are being adhered to. So wills, trusts, and then your power of attorney, medical power of attorney, and or your healthcare directive and your living will are two examples of ancillary documents, or the documents that I was referring to with regards to the term I liked the most that I heard recently was incapacity planning. So you haven't passed away, but in the event that you cannot make decisions for yourself, you are not coherent, or you're just not able to render decisions for yourself, who is going to step up and make those decisions for you? It doesn't have to mean end of life. It could be temporary. This is particularly important. I want to stress this just as a solo, as an entrepreneur for business owners. You have another layer to think about. So not just who's going to be paying the bills, paying the mortgage. We haven't even gotten into guardianship. I'll get to that right after. But who's going to make sure your business is running? Have you put a plan in place for your network? What happens with that to make sure that those bills can actually still continue to be paid? So just want to put that out there. It's called succession planning. If you haven't heard of it, or if you haven't explored that yet, it's a conversation worth having and getting something down on paper. And then the last thing that is something that we do is called a kids protection plan and loan guardianship documents. So you probably hear guardianship mentioned a lot in terms of who you name as a guardian in your will, but guardianship comes out outside the context of when you pass away as well. So standalone guardianship documents are important. They are important with regards to letting people know what your wishes are if you're just not able to, be there for a temporary period of time. And we'll get more into the benefits of a kids protection plan in a moment. So what happens without planning? So without planning of putting proper healthcare directive in place, I mentioned before, if you're incapacitated, unable to render decisions for yourself with regards to your healthcare decision, putting an agent in place that you trust to make those decisions is ideal. Why is that important? Much along the lines of same with a power of attorney and having somebody there who you trust, to make decisions with regards to your finances. If these things aren't in place in advance, the really important takeaway is that if nobody's been named, then the people who care for you and who are going to be trying to make decisions for you and act on your behalf have to go the long route, which is through the court, and apply for guardianship. And it's a long process, especially right now during COVID, to get that done. Why is it a long process? Because it involves people having to inspect the person that is being, that we're applying for guardianship over, whether it's temporary or permanent. It involves hearings that are now remote and a backed up court system. And so naming parties and giving them the power to act on your behalf prior to an emergency arising is not only in their best interest, it's actually in your best interest, because you don't want to delay either access to monetary resources, or you don't want to get in the way of you being able to get the healthcare you need in the event that you haven't named those parties. If you have more questions about that, please let me know. We talked a little bit already about what happens if you die without a will in place. One of the things I didn't talk about was somebody serving as a personal representative to administer your estate. So one of the reasons it's important that a will is in place and you've named a personal representative and that's been spelled out, is even just the process of opening the estate. It could be very much more costly to have to post a bond without a personal representative name. If you have a personal representative named in a will, you can post a nominal bond of $100. Otherwise, you're going and getting signatures of every interested party to the deceased. And if you can't obtain all of those, and sometimes that happens, then you're posting in a bond of sometimes thousands of dollars in order to account for the full value of the estate. And I know if that doesn't make sense, please feel free to ask me more questions. So if you die without a will, I'm going to skip that. So the part about the kids protection plan, I was kind of going over standalone guardianship documents. Planning and having a family plan in place for what happens in the event that something happens to you with regards to guardianship is very important. Let's just say you go out to dinner, you don't come home, you've left the kids at home with a babysitter. Whether you're out with your husband, your significant other, and neither of you come home, or if you're a blended family, maybe the other biological parent isn't somewhere nearby, all different types of scenarios, right? But the point is that legal authorities, police, are not leaving those children, that child, with the babysitter who has no legal authority to watch them. If there is no one with legal authority to come and get them, they're going to Child Protective Services. So having an emergency plan in place, having those standalone guardianship documents, having standalone medical temporary nominations of guardian for parties that are available, local, can be there, can show up as a part of your emergency family plan so that those kids don't end up with Child Protective Services. Having those things in place, is ideal. What did I just do? All right, guys, sorry. All right, so kids protection plan includes temporary nominations of guardian, medical directives, temporary medical directives for the minor children, so those temporary guardians can take them to the hospital, get them medical treatment if they need to, instructions to caregivers, instructions to guardians, information about your attorney, and ID cards for the kids to have on them at all times, informing them of who to notify, meaning those temporary guardians and those long-term guardians, their attorney, and their primary care physician if necessary. So those are some of the things you can put in place to make sure that you're covered. There's a full, well-rounded coverage with regards to thinking through your family plan. And so that's why it's more than estate planning. It's life planning. You're planning for the unexpected. You're planning for your life, your family's lives. And going beyond that, I think a conversation that I am surprised that more people don't have, and probably one I should have had, or my mom, I think my mom tried to have with me when I was on my way to college, is what happens when you have kids that are adult children. It's not just minor children that you need to be planning for. Adult children are going away to college, they're 18. Guess what? Legally, they're on their own. So what happens if they go into the hospital? What happens if something happens to them, especially during COVID right now? Do you have medical advance directive power of attorney in place to give you the legal authority? Yes, you still pay the bills. However, as far as the law is concerned, you don't have that legal authority anymore. So that's a very simple step you can take before your adult child leaves for school to make sure that you don't end up in a jam that becomes emotionally, financially draining, trying to navigate, and more than that, scary, because this is your kid that's out there on their own for the first time. What about your aging parents? This is me right now. I'm taking care of my mom. Not taking care of my mom like that, that doesn't sound right. My mom is fine, but I'm taking care of getting her estate plan in order. And honestly, I'm surprised at what I didn't realize she didn't know. And so it's a very important to have these conversations with our parents. And not from I find it helpful to approach it from a making ourselves vulnerable place. Letting them know that you're scared if something happens, letting them know that you're concerned. You just want to know where things are so that you can take proper care of them and take proper care of what's going on in the event of an emergency. But so having these conversations with our parents right now is important as well. So it's important to, when you're looking for an attorney, it's important to think about not just getting it done. So yes, there is LegalZoom. Yes, you see people advertising for quick, cheap documents. I feel like my practice is very much purpose-driven. I feel like the experiences that I've had are very much so that I can tell people exactly what things are. I've worked in pretty much every scenario. Like I told you before, I've worked for the big firms that are ridiculous, and I've worked for the mid-sized firms. And so one of the experiences I did have was with a firm that was one of these hot doc type firms, and there's a firm in Landover and a labor union firm, so they had prepaid legal services, which means they could come in and get a will, no charge, trust whatever. But really what I was trained to do was take down the information, fill in the blanks, and then we would pop those things into literally hot docs and spit out a form document. It had nothing to do that was specific to them. And one of the reasons why I left, not only because I couldn't practice the way I wanted to, was because I couldn't be of service to my clients the way I wanted to. So it's important to keep in mind that just because something is cheap and affordable doesn't mean that it's getting at what you need it to do. There are all kinds of subtle nuances in the law, and it's important to make sure that somebody is crafting something that's specific to you. You don't have to pay tons and tons of money to get something that's worthwhile, but it's important to make sure that person is paying attention to exactly what you need, not just form documents, not getting something offline. They need to be comprehensive in terms of making sure they're taking care of the will and what happens after you pass away, and then those ancillary documents that I was talking about as well. They need to be looking at the standalone guardianship documents, the kids protection plan that I was talking about. I'm just trying to give you an idea of what questions to ask when you're talking to an attorney and talking to an estate planning attorney. One that's going to be taking care of all of your needs is going to be talking about all of these things. So let me hop out of this and stop my share. I want the conversation, my goals, I wrote down what the goals were for tonight were to have fun, to connect with you guys, and to really make sure that I'm giving somebody information that they need tonight. So I'm going to pause right there in my presentation. That is I think a pretty good overview of the estate, what estate planning encompasses. Are there any specific questions about what I talked about tonight with regards to how to plan for minors, how to plan for yourself, or any of the documents that I talked about?
Hi, Ms. Stevenson, this is Lynette, and I do have a question. Could you go back to what you explained, the name of the document or the planning for minors? I have an 18-year-old that will be leaving for college soon, so you really gave me something to think about.
Sure, no problem. So I was talking about creating the power of attorney and the medical advance directive or living will for adult children. So these ancillary documents, right? Because life planning, estate planning is applicable to people of all ages, because we're planning not just for your end of life or passing away, but in case something happens to you. So in case something happened to your son, I'm sorry, I don't know if you said a gender, in case something happens to your child, They're either unable to communicate their wishes, they're unconscious, or maybe they're just out of it somehow and not with it and can't decide something for themselves. By naming you as their agent, you could effectively step in on their behalf to do things like, let's just say they have an apartment, pay their rent, withdraw money from their account, assuming they haven't made you the joint person in their account, which I know a lot of parents do that. In the hospital, being able to be the person that's in touch with them as their advocate, that's their last line of defense when it comes to their medical treatment. Very important. Making sure you're named as their agent on their advanced medical directive, it's what it's called. So healthcare directive, power of attorney. Your power of attorney gives the power of attorney naming them as you as their agent on a power of attorney gives you authority to act with regards to financial decisions. Healthcare medical advance directive is authority to act with regards to medical decisions. So two different lanes.
Thank you.
Okay, I want to talk a little bit about trust and the two different types of trust, because I didn't want to jump too far into that, but if there are no other questions right now, I'm going to talk a little bit about that. So the first type of trust I'm going to talk about is called a testamentary trust. A testamentary trust is shows up in the language of a will. So you're a testator, you're creating a last will and testament. It's a testamentary trust. It shows up right there in the language. It doesn't exist as an entity until after you pass. And sometimes I also like to refer to it as a springing trust because it's more descriptive. So it only springs up in the event that something happens. In the event that you pass away and somebody, an heir, your child, a niece, a nephew, somebody you've left assets to, money to, has not reached the age of 18 or an age you've specified, a trust will be created in their name. Now, if you pass away, if you passed away and they've reached the age of majority or they've reached whatever age you've designated, then obviously that event didn't occur and this trust will never be created. But a springing trust gets created in the event that you pass away and somebody hasn't reached an age to take whatever you've left behind. And what does a springing trust or a testamentary trust allow you to do? And this is in the language of your will. So you've gone to an attorney or you decided to create a will and this is why it's important to talk to an attorney. You decided to put in a testamentary trust. And you now can spell out when your minor child can take possession of whatever assets you left behind. So what are some examples of that? 1/2 at age, Billy Sue can take 1/2 at age 25. I encourage people to start at age 25. Why? Because age 22, you're just getting out of college. And if I were 22 and somebody gave me some money, I would be buying, well, back then it would have been a Nissan Pathfinder, but I would have been buying a car, So 25, you've been out for a little bit, you've been paying some bills, hypothetically, even a better idea of, maybe what the practicalities of money are, maybe just a little bit better than age 22. And so the follow-up question to that I get is, well, if I'm holding it up for them until they're 25, how are they going to use it for school? Well, the answer is that even though it's in a trust, they do have the ability to petition the court to use it for things like education. So health, education, medical needs, braces, something like that. There are ways to access the trust before they reach the age that they need to, but you still put parameters on it so it's not a free-for-all. So what are the options? 1/2 at age 25, the other 1/2 at age 28, or 1/3 at age 22 if they've finished a 4-year institution or gone to the military. You can be as creative as you want with that. So that's a testamentary trust or a springing trust. Springs up in the event that something happens, the event being that you've passed away and the person you've left something to has not reached either the age of majority or an age that you've specified as being appropriate for taking those assets. Other types of trusts, and these are the types of trusts that when people are saying they want to avoid probate, they come into my office. And these are sometimes what I refer to as like a lockbox. I don't have, do I have binders handy? Yes, binders handy. So when people come to my office, I show them the binders that we put the trust in. This one's empty. And I say, this is the lock. We're creating a lockbox for you, right? We're going to create this lockbox and it's going to hold your asset. Remember, I said retitling assets. Retitling, putting on the name of the title, the name of your trust rather than your personal name. It doesn't mean that you've relinquished control, but it does mean that you've changed the name on the title. And so we're creating this lockbox, and this trust exists. I don't want to say it's living and breathing. It is type of living and breathing while you're still here. It's not that springing trust that comes about in the event. It's here. Now, this will be a revocable or an irrevocable trust. And it works a little bit differently than the springing trust I was talking about. But when parties want to, quote unquote, avoid probate, what they're doing is they're retitling their assets into the name of this living, breathing trust, this lockbox. And they're passing down their assets to their heirs by this instrument. And you can create those same controls that I was detailing about age 22, 25, godly life, all of those parameters. You can use those same controls when you're using the irrevocable or the revocable trust. It's just a matter of, does it exist at the time that you're living, or does it come about after you passed away? That's a personal choice. You create more structure, peace of mind, control by taking care of it before you pass away. Not everybody's preference though. Is it slightly more costly? Yes. How much more costly? We're talking the difference between a will and a trust is less than $2,000. Is it worth that investment? For a lot of people, yes, for that peace of mind. What are the different scenarios that I'm talking about? I feel like I'm talking to all women tonight, so if I'm wrong, I apologize. But a lot of times we have blended families, so we might have, trying to think of something recent. Dad remarried and we don't, necessarily trust the new wife with, something happened to you if they're going to be raising the kids. We don't necessarily trust new wife to be spending the money on your kids. Creating a trust and putting somebody else in control of that kind of takes care of that concern. Oh, there are two guys on here. Okay. So same thing goes. I do it for the guys too. Same idea. So you're creating, you're creating structure, you're creating control over your assets and what happens after you pass, but you're also creating some protections and avoiding some costly emergency scenarios by doing that incapacity type of planning as well. And I'm leaving off the guardianship and the kids protection plan stuff, but I think I've been talking for almost an hour. So Regina, I will stop. I just want to remind everybody, so I do practice estate planning. I also practice family law. I specialize in custody litigation. I've been doing that for a long time, as well as small and family business law. So business law and formation, basically trying to help families, business owners, individuals plan for anything. That's why I call it life planning. It all kind of comes together. And so I love being a part of that conversation. If you guys need any help, feel free to contact me. I'm going to put my information in the chat box, and Regina also has it as well.
Are there any further questions? Don't be shy, she's here. And she'll answer them.
I will answer them. And if you're too shy to answer them, ask them, feel free to, I'm gonna put my information in right now. Feel free to reach out to me one-on-one, not a big deal. I'm pretty accessible, so.
Awesome. As always, I thank you for being so willing to share your information, and I'm sure those that need to will reach out. For everyone who is on the call tonight, thank you for being the best part of Why Not Inc. If you have not already, please check out the website. If you have not liked and shared our Facebook or Instagram, please do so. We do have upcoming events. Our next Parent Power series will be actually next week, and we'll be talking about knowing your rights. We will have another attorney to talk about knowing your rights. And in the climate we're in, I think it's a very timely topic, especially for our Black and brown people at this juncture and some of the things that we're going through. So once again, like and share Why Not Inc. and you will receive a survey asking for suggestions on how we can improve and even some topics. If nothing else, everyone have a good night.
Thank you, everyone.
Thank you.
Thank you.
Thank you. Great information this evening.
Thanks, Regina. I appreciate you. All
Thank you. We'll talk.
right. Have
All
a good
right.
night.
You too.